Chaos in the Trump classified documents case in Florida, and we've got a transcript to get into. There was a motions hearing taking place. We were talking about a lot of complicated things like SEPA and when the trial's going to happen and whether Donald Trump has access to discovery and how much time the government needs and so on and so forth. We've got a lot of Trump trials coming up, but the Florida case is kind of getting the back burner after the January 6th case, and there's a lot of complications here because Jack Smith is the special counsel who is prosecuting both of them. And so the judges are wondering, hey, how can you balance both of these trials kind of simultaneously? We know you filed the classified documents case first, then you said you were ready for trial, then you filed the J6 case, and now you're ready for trial on that one. And so we got a lot to unpack here, and we're going to go through it. The person who's been doing some amazing reporting on this is Julie Kelly, and she was very nice to give us the transcript that we'll be able to read through today. So be sure you go follow Julie Kelly on X at Julie_Kelly2, and of course on her platform called declassified.live. I subscribe over to her, and I'd encourage you to do the same thing. She's very, very, very important in the work that we do. But this is a hearing that she attended, taking place on November 3rd. The court heard argument from the parties on pending motions to continue. So a postponement, extending the trial out. Total time in court was 1 hour and 38 minutes, and a bunch of people were there. Jay Brett, who I've learned a little bit more about, David Harbach, and many others were there in court. And so we're going to go through what happened in this proceeding because we're learning that there may have been some collusion between the special counsel's office and the Biden administration, if you are surprised. So we're going to check back in with some conclusions from Julie Kelly. Make sure you're following her. But this is what the transcript sounds like. And this is out of Florida. Southern District of Florida, Criminal Division, transcript of the motions hearing in front of Eileen Cannon, United States District Court Judge. Bunch of people are there. Christopher Keese, Todd Blanche, the same people who were there in the New York trial are also showing up in the Florida case. Stanley Woodward, the lawyer for the defendant called Walt Nada, and De Oliveira also present. Here is what it sounds like. Court is beginning. It's an afternoon session. Clerk says... All right, appearances, please. This is the judge speaking. All right, appearances, please. Government, Mr. Bratt comes in. He says, good afternoon, Your Honor. Jay Bratt here, David Harbach, Michael Thaker, and others from the special counsel's office. Good afternoon, says the Judge Cannon. All right, well, let's hear from the counsel for former President Trump. Good afternoon, Your Honor. Todd Blanche here, joined at the table by Emil Bove. Christopher Keese is also dialed in on the phone. Keese says, good afternoon, Your Honor. Can you hear us okay, Mr. Keese? I can, Your Honor. I'm going to leave my phone on mute, though. It's fairly noisy here. I'm at the UN courthouse, but thanks for letting me appear by phone. Judge says, okay, all right. All right, so counsel for Walt Nada's here. All right, everybody's made their appearances. Judge Cannon speaking. All right, this is a hearing to discuss defense motions, so Trump and the other defendant motions, for a revised pretrial and trial schedule. Now, as usual, no cell phones here, no broadcasting, don't do anything here. We're all set up, overflow room, Zoom feed, blah, blah, blah. Now, as background, on July 22nd, this is Cannon speaking, saying, following a hearing that was held previously to the return of a pending superseding indictment, and a superseding indictment comes after the fact. You get one set of charges and they say, we want to add a bunch more of charges. Okay, well, here comes the next indictment. Well, the problem with a new indictment, it kind of means that everything you said about the original indictment is either moot, or if you said like, we're ready for trial based on the first indictment, and then you bring in a second indictment, you got to ask yourself, I thought you said that government that you were ready the first time. So if you're ready for trial and then you're going to add in a bunch of additional charges or maybe even another co-defendant, were you being honest with me when you said we were ready originally? Because you just like changed the whole case. So are you being honest or not? So they say, okay, the court entered an order granting in part the government's motion for continuance, and we reset a bunch of deadlines because we've also got SEPA that gives us some deadlines. So we got all that backstory. Okay, some stuff got changed around. So now pending before the court are other filings. She's like, I've got a bunch of stuff. We're going to hash through it. Now, a lot of these things move in combination, and all the defendants joined these SEPA motions or SIPA motions and defense motions to compel discovery. So Trump and Walt and Oliveira, they all want the government to give them discovery that they're not getting now, and they want additional trial deadlines imposed. Now, of course, the current trial is scheduled for 2 weeks in May of next year, which is pretty soon, isn't it? We're going to have the January 6th case is March, the day before Super Tuesday. Chutkin is not going to move that one unless she has to. They want a conviction well before the final votes. So this is a hearing to discuss those motions, all of these other motions. And because they're defense motions, we're going to start with the defense. Have you guys come up with a presentation motion format because we got 3 co-defendants. So who are we hearing from? So Trump's lawyer jumps up, Mr. Blanche. Your Honor, I'm going to be presenting on behalf of Trump the motion, and then to the extent that Nada and others, they want to supplement, I expect them to do that. So Trump's lawyers say, we're taking the lead. The other guys can jump in if they want. Judge says, okay. Let's start with you, Mr. Blanche. Now, I see the issues raised in these motions falling into different categories. You know, we got a big picture. We got some specific discovery issues, all the granular details that go along with that. So I'm going to use this hearing to try to help the court fully understand what we're talking about. And we're also going to talk about unclassified and classified stuff. Todd's nodding away. Yes. The next sort of the big bucket, I'd say, are concerns about the scope of any defense motions to compel. So Trump wants the government to give them material. How much of that material, she says, we're going to have to debate. That segues, or I think it's considered along for SEPA, Section 4, which I think is also illuminated from the court's order entered today on the subject Section 3 versus Section 4. We're going to skip all that. And then finally, there is a category of logistical concerns. And under that category, I'm thinking the complex and numerous issues associated with classified discovery and logistical issues and a lot of stuff. Establishment of overall facilities to look at the document. And so the judge is laying this out. So that's kind of the overview. I mean, those are kind of the issues that I see have been laid out. And he says, yeah, it's great. So let's start there. And Todd says, thank you, Your Honor. Sounds great. So I want to start by addressing unclassified discovery. And we discussed this previously. We know Your Honor is aware of this. All right. There is a lot of discovery. Okay. It's extraordinarily voluminous. Tons. The most, and the special counsel, if they've represented to the court accurately, they provided a lot of material that in many cases, the defense won't get so early, including grand jury transcripts and other things. And it's certainly helpful. In other words, they've said, we've gotten some things pretty quick, like the initial stuff. They got it to us fast. Okay. Grand jury transcripts, Jenks material, and 3500 material. We've gotten it all. And it's been very helpful. But the discovery itself remains extraordinarily complicated. And it's voluminous, especially as it relates to the CCTV footage. Very cumbersome, he says, if not impossible. And I can certainly let co-counsel speak to this. We've got a lot of issues. We simply can't load it in an effective way to review it. And so this is extremely common, by the way. Analyzing CCTV footage, when I was practicing criminal defense, is very difficult. It's almost impossible. Like they're all, you know, Chinese knockoff systems, and they're all incompatible, and they all have different codecs, and they all have different security features. So like pulling it off, it's a nightmare. Unless they like give you a CD-ROM or something, it's a nightmare to pull it. Nobody can ever access their footage. Once you get it loaded, you got to get proprietary software. It's literally a nightmare. And this is the same thing. This is a problem from the government, by the way, often. Like this is Trump's CCTV footage, but even the government files are bad. Like they get it and they're like, hey, we put it in our system and you can download our prosecutor's system and nobody can use it. So they say the special counsel has directed us to certain portions of the footage that they say are the most relevant. But what we think, there's a tremendous amount of footage that we believe has been produced that is not what they have identified that is extremely relevant to us. So they say, well, you don't need to look at it all. We'll give you what you need. And they say, no, we do need the rest of it. So for example, we need to know the extent that the boxes were moved on occasions or other things that were delineated. And so we need to know that. Like we got to see this footage. We can't watch it. My co-counsel can't watch it. Co-defendants can't watch it. Nobody can figure it out. So the judge says, okay, so hold on a minute. So on the CCTV footage, how exactly? Because you're throwing a lot of numbers around. In terms of terabytes, disk, documents, records, that's kind of what I'm struggling with. I want to get particular details. So on the CCTV footage, the judge wants to know how much is it? I say, well, there are different views on that. Okay. From my understanding from Trump, it's multiple cameras. Some show the locations depending on the format. Sometimes you can view it. However, up until this point, we even can't get that done. Now, Jack Smith's office is working with the defense to try to figure out how to get a computer to look at this stuff. But when we had our vendor, it took them, our vendors, almost a month or 3 weeks. Our vendor, like the people who are pros, it took them 3 weeks just to view one video, which obviously we can't do that. And so we're not asking, we're not assuming that that's practical. So if you just play it out in minutes, like if you just look at all the footage, it's literally years of footage, like if you just played it. But putting that aside, there are some cameras that are of the same location. So in theory, you can watch those, but we're working our way through the discovery. Cell phone evidence, there's a ton of correspondence, and we have continued to get discovery from Jack Smith's office. And that's not unusual. I'm not saying that it's unusual, but we have continued to get discovery from them since the initial production. And we've been working our way through it all. We're steadfastly trying to do this. But now I want to turn to classified discovery. It's very related. And the challenge with the classified discovery is that until a week and a half ago, we were in a location that was very difficult to work in. It was temporary, very small, very challenging to study the classified documents in a way that we could look at it. It says, and we requested special counsel to get assistance here. They say, and there was a lot of it that is obviously very related given the nature of the charges. The fact that there were, allegedly classified materials found in connection with unclassified materials, we want to know the details. For example, there was a picture that was provided provided in classified discovery or a couple pictures, but the bulk of the data from that phone was unclassified. And so we requested that we get the full contents of the phone inside the SCIF so we could review it. But it's been very difficult, as Your Honor knows. From the various briefs that we've submitted, they won't give us access to the documents. Judge says, let's understand that. As of what date was all the classified discovery produced minus these small things? He says the 17th. And by the way, special counsel criticized us for the fact that there was an 11-day window between that day that it was apparently available in DC and available to be delivered to the SCIF. On Monday, we had Columbus Day. We found out Friday night we had SEPA filings. Special counsel knows this, so they're giving us grief for no reason. So it's not as if we found out that we had additional discovery and we just waited 11 days. We left on Thursday, found out Friday there were additional materials, and all this time took place. So Judge, we're moving fast. Don't believe them when they're saying we're not. So at this point, have you had access to all of the classified discovery? We have, Your Honor. We have had access to all the underlying discovery for the counts. And that happened, you're saying, on the 17th when you were able to be here locally. Is that right? Well, there was a series of documents that I believe were flown down the next day, but yes, Your Honor, yeah. And we understand there's some additional classified documents discovery taking place in the SCIF yesterday, and we didn't show up because of miscommunication. We didn't know it was there, so we know there was some more discovery in the SCIF as of last Tuesday. They notified us. And so, Your Honor, not to belabor the point, but we spent a lot of time looking at discovery in the SCIF, and when we talk about asking for more time or needing more opportunity, it's not because we are not going down to Miami regularly. We're almost in Miami there weekly, but there was a meaningful, and as Your Honor knows from our filings, we put a letter to the special counsel asking for a tremendous amount of different documents that we continue to believe we're entitled to. Jack Smith still has stuff that they want, but won't give them. So in response to that, we did get some additional documents. There have been several thousands of pages that we've got. They're extraordinarily dense. Well, they're memos, and they're very challenging materials to get through in a SCIF that special counsel, when we found out about it and we asked if they would agree to more time, literally said in an email to us that 2 days was plenty of time to review the documents. So he's saying they sent them like complicated things and gave them 2 days. And so, Your Honor, somebody blank make motions to compel. And I don't say this lightly. That is just not true. I mean, we're talking about over 1,000 pages, and we're not talking for the most part about grand jury transcripts or other things. These are very dense materials, and we're going to need time to review them. Now, we submitted another demand last night to Jack Smith to get the classified discovery, but we just got it, and we're just going through it now. But we are sure that we are going to need to file motions to compel. They've got classified materials they're not giving us. Court says, all right, hold on a minute. Now, you said you have gotten some answers to your questions. Have you gotten yet an answer as to whether they conducted their prudential search reviews? So anytime somebody's under investigation by the government, one of the things that you ask them to do is ask for exculpatory information from other agencies, right? Trump is being prosecuted by the DOJ and the FBI, but do other people have exculpatory materials? And maybe they should go search because the government is big. Trump lawyer, did the government confirm that they did those searches? Trump's defense says, Your Honor, vague answer. We received some of these, but we were told, as I think was also told to the court, something vague about what they believe they were required to do under the law. So they haven't affirmatively said, here is what we did, here is what we didn't do. What about classification reviews? Have you guys received all of those? No, Your Honor, we've not received all of them. That is one of the things that we're continuing to ask about. We have received them for some of the documents, but not all of them. All right, what about other Jenks Act or Giglio material that is used by law enforcement witnesses? So these would be things that the witnesses are relying upon to testify. There was some discussion of that. He says, we have some, but we know from the review that there's a lot more. I mean, maybe it's obvious, but there will be references to communications and other emails and other communications, and we haven't gotten any of those. So we understand there has to be more material that is coming, and we just haven't gotten it yet. Now, there was also some reference to the special counsel's definition of its prosecution team. Have you gotten any more clarity on that? He says, yes, Your Honor. So this is an interesting question. Who is Jack Smith's prosecution team? Good question. Well, Your Honor, they quite surprisingly are taking the position that NARA is not a part of their prosecution team, the National Archives, which is curious because they were a government agency who's in charge of the records, in charge of the classified documents. So Jack Smith says NARA is not part of their prosecution team, and that many of the intelligence agencies are not part of the prosecution team. Now they say, that's curious because they're prosecuting him, like literally, oh, my classified documents are wrecking the world. So we're going through evidence, says Trump's defense, both classified and unclassified. That will be part of, assuming they don't change their mind, will be part of a motion to compel. The big question for Your Honor will be whether NARA is in fact part of the prosecution team, which might enable them to get access to some more materials. They say, Your Honor, we have seen communications between NARA and the DOJ and the White House and the special counsel that started way before what has been publicly disclosed. I want to read that again. So important. Trump's defense says we have seen communications between the National Archives, the DOJ, the White House, and Jack Smith that started way before these were publicly disclosed. Extensive meetings, extensive communications. And so we feel very strongly and expect that we are going to win on that NARA isn't part of this. When we filed the motion that NARA is absolutely a part of this prosecution team and the intelligence communities that they worked very closely with in determining, from what we can tell, the particular documents that they chose to charge. So there is purportedly a tranche of documents that have classified headings on them, of boxes and boxes and toilets, and then only 32 of them that they decided to charge. This wasn't done in a vacuum, Your Honor. They didn't just, pick 32 documents out of a hat and say, well, we're going to go with these. There was a lot of coordination that we can tell from the materials that we do have with the intelligence community that ultimately led them to proceed the way that they did. So yes, we have an answer with them. They say very strongly that they view the prosecution team as being limited to Jack Smith's office and the FBI, and we very strongly believe that's wrong. It is, because NARA was involved, as I'm going to suspect was the Biden White House, orchestrating this whole thing. Court says, okay, all right, you hinted at this a little bit, but on the subject of the motions to compel, what categories do you anticipate your motions to compel? I know this is somewhat in flux, but if you can shed some more light on that. Yeah, so there's a broad range of discovery we believe we're entitled to, that if we're not able to meet and confer and reach agreement about, we're going to file a motion to compel, Judge. Like, we ask you to order it to be given to us. The most significant, for sure, has to do with NARA and to do with the communications of Jack Smith's office, and that the DC U.S. Attorney's Office was emailing NARA before Jack Smith was accounted for. The White House and other intelligence agencies, they were all colluding to get Trump, and they were changing the classifications of the documents, or they were changing the categorization internally of the documents. Illegal, not illegal, Trump took them, can we get them, what documents does he have, right? All of them working together, so they're all part of it. So if there's anything exculpatory that's in possession of NARA or in possession of the DC Attorney's Office, that when he was not at the Special Counsel, shouldn't all that be fair game for exculpatory evidence? I'd certainly say so. And we know, says Trump's defense, that we don't have it all. We can tell from what we do have that there's a lot more out there. So there is also all the prudential review for sure, the way that the intelligence community decided why certain documents are classified and continue to be closely held. And there's a lot more information we don't have about that process. And so we ultimately got to get that done. There's also a category of documents that it actually unclassified discovery. Now this is curious. We learned a week or two ago that there's a certain category of classified documents that require what is called a, quote, Q clearance. A Q clearance is an official type of classification, and it includes one of the charged documents. So something was for Q clearance level only, and Trump had possession of it. We learned that it's a Department of Energy program. Now, we also learned that President Trump continued to have an active security clearance even after he was indicted in this case with the Department of Energy. So, insane, but they charged Trump with a crime, even though he had active Q clearance security by the DOE. It includes one of the charged documents they said Trump possessed illegally. Okay, so that's one count that is, I would say, is automatically gone. Trump was in possession of a DOE energy document. They said it was illegal. Turns out not. He actually had Q clearance. That is the definition of stuff that he should know. And we can't know whether he had active Q clearance or any other clearances unless we expand the scope outside the FBI and the current special counsel. So he says now that, in our view, is the definition of Brady. It was, I'm not going to say it was buried, but it was provided to us in discovery as part of miscellaneous materials at some point in the third or fourth production. He says, I mean, it's literally a memo from the Department of Energy dated in late June of this year. So June 28th of this year. And they sent a memo at the DOE. They said, oh, we should remove Donald Trump from the person who has active security clearance. We should just take him out of active role. He's been charged with possessing a document in violation of federal law when he has an active security clearance with the holder of that document. So they charged Trump, literally, Trump's defense says they charged him with a crime, saying that he didn't have clearance, and he does have clearance. And they knew that, and they hid it from us and tried to bury it in the fourth production. So anyway, Trump says, his defense, there's a category of materials such as that we don't believe we have in discovery. Like, we need to know that stuff that they're trying to hide and bury. That it's going to be a part of our motion to compel. So the judge says, okay, so why wouldn't, turning now to the sequencing, why not go through Section 4 process for that? Section 4 SEPA stuff. He says if we file that next week, we're going to have multiple rounds. You're saying it's going to be inefficient. It's going to be incomplete, inefficient. And he says, yeah. He says, I could put a finer point on that. He says Section 4 is a big deal for the the government. They're saying to the court, there is discoverable information that we don't think the defense gets, and they should only get affirmations from the AG. They should get the affirmations from the intelligence community. And he says, so it is a big deal. This is happening right now, by the way, in the January 6th case. So Judge Chutkan has basically ruled that Trump, not basically, has ruled that Trump does not get certain classified materials because it's protected under SIPA. And they're trying to do the same thing here, but Judge Cannon's probably not going to let him. Let's see. So we're going through this process and we're filing motions to compel. Let's say some of them are granted, and then we can get back on track. He says, we want the government to answer our various discovery demands. We gave them one last night and one this morning. We need these things. And we're not able to meaningfully meet and confer in order to get this stuff done. So I know at this point, it's just more efficient to go this other way. Do you have any sense how long it's going to take to complete the motion to compel process? No. We commit to filing our motion within 2 weeks, and we'll get it here in short order. Now, she says, let's shift gears to some of this SIPA stuff, and says, Your Honor, we believe that here in this case, the court certainly has discretion to conduct its investigation. You can review these filings ex parte, which means separately. Jack Smith has submitted motions to the judge specifically and not copied Trump's defense on it. And so we're asking about that. And the Trump's defense is saying, yeah, you have the right to do that, and cleared counsel can be involved. Says, does the 11th Circuit impact your opinion? Says the whole point of SIPA and Section 4 is for Your Honor to be educated about this. And so, okay, she says, the Judge Cannon says, and then on the subject of logistical issues, I'm curious what your thoughts are on operational logistical concerns. He says, well, I'm not trying to be flippant with the court, but Your Honor considered the motions last year. So putting aside the new filing, right? They filed a superseding indictment. I just want you to know that Jack Smith completely disrupted everything about the schedule that Your Honor set. There's not a single part of Your Honor's schedule that is not adversely affected by the DC schedule, right? Because this case was filed first, and then Jack Smith said, we're ready for trial. And then he filed another case in DC, and that wrecked everything. So Your Honor, you were first, and the schedule set by that judge was demanded by Jack Smith in DC. Okay, he said he wanted a speedy trial. And so to the best that we're aware, Judge, without any regard to Your Honor's schedule, you know, we put a notice in and we've alerted to Your Honor about this. So they're playing both cases against each other. But it's troubling to us, Judge Cannon, that even as late as last week, the government accuses us of being sinister. Sinister because we're bringing to the court's attention the fact that Trump now has, putting aside his counsel, President Trump now has what amounts to probably a 2.5-month trial starting in March in advance of May 20th. 2.5 months, right in the middle of an election. Trump's going to have to sit there every day in the January 6th trial in March. Then they want him to do the same thing in May so that he cannot campaign or be active at all. The court says, can you tell me when is that trial set to begin? March 4th. And where are you getting the 2.5-month estimate from? Well, there's a little bit of speculation here. The government says 4 to 6 week trial, and we're expecting a 2-week defense. Honestly, we're still about 20% of the way through the discovery there. And our understanding with Chutkan's courtroom, is the voir dire process, jury selection, is going to be very complicated. Jury selection is not even going to start until the 4th, and then we're building in time for deliberations. And so when you add that, when you put it all together, you're at least 2 months, maybe even longer than that. Judge is like, yeah, that sounds right. Shoot. Okay, anything further from you? I'll give the other defense attorneys an opportunity to be heard, then I'll turn over to Jack Smith's office. No, he says, look, I don't want to belabor the point with scheduling. It's just that in our position papers, but the real pressure on President Trump and us is a combination of a compressed schedule, compressed in DC, very aggressive schedules elsewhere. And so even with the pretrial motions that are in this case, these are going to be extraordinarily voluminous. We've got a series of deadlines. We're also in January in the DC case. We got motions on the table. We got SIPA litigation. It's voluminous. Oh, okay. He's just like ranting, right? And the judge says, okay, listen, I get it. I think I get the point. There's a lot of work, and clearly there's a lot of moving parts. And he says, yes, Your Honor. He's just like, help. So the other two individuals jump in. And so Woodward's team makes an argument. Keese is still on the line. Woodward says, we will never forget Mr. Keese. You see how defense attorneys act? You see, we care about each other, man. We're good people. These prosecutors are the worst. Defense attorney, we're never going to forget about Mr. Keese. We love you, brother. Shout out to Zoom, because they're going to turn over to the government at some point, and it looks like we're not there yet. So counsel for Mr. De Oliveira is here. Mr. Keese jumps back in, and now it's Mr. Bratt. Oh gosh. He's a government prosecutor and one of the worst. So now he's back. Judge is asking him questions. All right. Thank you, defense. Amazing people. Now I'll hear from the government. Mr. Bratt or Mr. Hart, Arbach, Mr. Bratt stands up, says, I think one starting point, Your Honor, is to look at this from a perspective of what the defense position from the outset of this case, and since they have raised the DC case, and also what their position is, and that Trump wants to delay it as long as they can. It's not surprising, says Bratt. He says, given that back in July, they were asking for a trial date after November, and it's not surprising that their motion to change these dates all wants to push it until after November. Says the court cannot let or should not let the DC trial drive the schedule here. In the DC case, they're making the same arguments, but they have not yet filed a motion for adjournment, and so they've not talked about it, and the judge jumps in, cuts him off, says, hey, do you know, Mr. Bratt from the DOJ, do you know of any other case where the same defendant is facing indictment in multiple jurisdictions and the DOJ has taken the position that there should be no consideration to the fact that, of course, the defendant needs to be able to assist in his defense, and there becomes an unavoidable reality that the schedules collide? Any other examples, Mr. Bratt? He says, so they collide. Okay, we don't know that's going to happen. You know, in the DC, can you elaborate on how you don't know that, Mr. Bratt? Because judge cuts him off again, not happy. From what I'm hearing, the schedule is looking like it's going to consume March and April, which is the trial, possibly going into May, and that's to say nothing of trial prep in this case. So Bratt, your office scheduled this one in March, and you're not even telling us about preparation in my case and all the many steps that we haven't even embarked upon, and I'm just having a hard time seeing how, this is the judge, how realistically this can work. How can this be accomplished in this compressed period of time, given the realities of what we are facing and the multiple material developments that have come to light since the initial schedule was put into place back in July? You guys brought a superseding indictment which introduced a new defendant into this case. Not to mention the multiple logistical issues that I have indicated with the SCIF and the security procedures required to review this information. So I'm not quite seeing, Mr. Bratt, in your position, a level of understanding to these realities. Somebody's in trouble, man, big time. Bratt says, so, and I understand everything the court is saying. A lot of this, though, is in the realm of the, I don't want to say hypothetical, but it is in the realm of we don't know what's going to happen. We don't know what is going to happen in this case. We don't know what is going to happen in DC. Among the things that the defense has raised in the DC case is if that there are adverse rulings on any of the pending motions to dismiss, that they would seek an appeal and a stay of the proceedings. And so that could happen. We don't know. Now, obviously, there are arguments both ways. There are arguments for the trial court and the DC circuit, but the trial date could disappear. And so we understand that. Bratt's saying, we understand that competing demands on the former president, he's got multiple trials, and I think he stands apart from his counsel. It was he has the right to counsel of his choice, and he did choose Mr. Blanche and his firm knowing they were already involved. But Mr. Blanche and his firm took the representation knowing they were involved in that case. And he says, really, my argument to the court is that we should keep, and obviously there has to be some modifications, particularly with SEPA classified, but we should keep on track towards the trial date that is present. They want both trials to go before the election. Like, that's all they care about, because it's going to bog Trump down in trials. He's going to be sitting in a courtroom, and it's going to cost time and money, and his lawyers are going to be doing those things, and the media, Trump trial, felony. So he's just digging in. Now, he knows he's on the back end of a losing argument, but he says, things could happen, Your Honor. Things could happen with the DC case that would make going forward in May perfect. And that could be feasible. So like if there's an appeal and Trump and the proceedings are stayed pending the appeal, or the Supreme Court steps in, maybe we could go on the 20th. So let's just leave it. That may happen, and we can address that at this time. And we should be moving forward in this case. Bratt. Judge says, oh, certainly. Yeah, I think we should be moving forward, not questioning that. Yeah, I think we share that view. We're moving forward, all right. Can you drill down on the discovery particulars that I was talking about at the beginning of this, Mr. Bratt, so I can get a better understanding? We've had hearings where we discuss numbers, okay, quantities, data, disks, etc. I know there are a bunch of responses to the SDO, but I would like to get, if you can, is just a rundown of the unclassified and the quantity of the data associated with that, and then shift over to classified as best you can. Just give me an update on the things I've identified. I would be happy to, Your Honor. So first, I'll start on the unclassified side. He's flipping through his files. We produced approximately 1.3 million pages of classified discovery, and that includes, as we've set out in our various pleadings, almost 200 witness interviews, grand jury testimony, all the 302s, interview notes, all agent notes, and all of that. Judge, this is classified? No, this is unclassified. Okay, unclassified, just to be clear. There are some, says Bratt, there are some classified transcripts, and actually, Mr. Blanche, and sorry. Let's try to stay organized here. So I'm writing this down. Okay, sure. So on the unclassified piece only, you said 1.3 million pages. That's correct. Does this 1.3 million pages, does that include CCTV footage or any other multimedia? So it's, Your Honor, those are the documents, the digital documents that somebody can look at and read. The CCTV footage, the judge says, is what? Separate? Right. You can't put pages on it. Correct. So, but there is all the CCTV, and the judge says, would you agree with Mr. Woodward? He said it's about 60 terabytes. Is that right? That sounds about right. Yeah. Okay, so from what I've heard, says the judge, from a pure temporal perspective, approximately 9 months because of the multiple cameras, it turns into almost 2 years of watching unless you can collapse it into one screen maybe. And Jay Bratt, the prosecutor, says, well, I think we disagree with them on the actual math. It's a lot. All right, it's true. Now, it is several years worth of materials of video footage. I think their number is 10 years. I think it's less than half of that, but it is a lot. It's important to look at it in context, okay? Some of the key dates for this case are May 11th, and that's when the grand jury subpoena was served. August 8th, when the date of the search of Mar-a-Lago occurred. Those are the key dates for viewing the testimony. You don't need to look at anything else. The key location is Mar-a-Lago. I mean, we did get stuff from Bedminster. We did get things from somewhere, but the key location is Mar-a-Lago. There are cameras on there that are on 24 hours a day. There are cameras that are motion activated. Some of the cameras are on 24 hours a day. For one example, there's a camera that looks at a retaining wall. That's all you see. You may see birds come through, but it's looking at a retaining wall. Well, how do we know that? We don't know that until we watch the whole damn thing. Sorry, that's how it works. Nobody trusts you, Jay Bratt. I think it is a security camera. It's possible somebody might be able to go over that wall, but it is just looking at a wall. And I don't dispute that they have a right to view these things, but there was a key time period to be looking at, and that's May 11th, August 8th. So we pulled for them what we believed are the key periods and the key footage. So again, it's like highlighter girl's back, but that's Molly. She's up in DC. So again, they have every right to look for other things. That's true. And I won't get into a debate with Woodward about the theory of his case. I think we have a theory about where things are, and they have an opportunity to look at things. He says, and look, now I appreciate the kind of things they've said to us about our responsiveness on this. They said they got him a bunch of stuff quickly. And I also appreciate Mr. Woodward, owning the fact that he waited 3 months to ask us for the array, now dunking on him. But they have had this material for a very long time. It was actually the first I've heard today that Trump's counsel has been having issues viewing the footage. Never heard of that. And we have enlisted technical experts to assist, and we'll continue to do that. But they have the periods, and they should know where to be looking. Judge says, okay, thanks. Now, is that the full scope of the unclassified? Is that everything? That is the full scope of the unclassified. So just to be clear, 1.3 million pages, that's a top line number, right, Mr. Bratt? Yes, that's a top line number of all the unclassified, essentially, documents that are in this case. Okay, and all of this information has been produced, right? It has been produced, yes. Okay, and the bulk of it was produced in July. Judge says, when was the last production? So our last production, a very small production we gave them, was I think last week. It was like 138 pages, and that was in response to their letter. So okay, shifting gears now, let's talk about classified. He says, correct. Is it 3,500 pages, or what exactly is outstanding? He says, I know that there are some disks that have been added to the mix, or perhaps they were always there, but in any case, some details would be, Bratt says, sure, would be useful. Bratt says, okay, Judge, so in our first tranche of documents that we produced, there were 2,500 pages. Judge says, 2,500, okay. Now that was produced on September 13th. Now over the following 3 weeks or so, we produced an additional 3,000 pages, so there was approximately 5,500 pages of classified discovery in the SCIF. Does that include the disks? Well, the disks are separate, but it is important to understand what is on the disks. The disks include photographs of both unclassified documents and the very same classified documents, hard copies of which they now have in the SCIF. And there's nothing unique about what is on any of the photographs that's on the disk. So what you're saying is there is nothing in the disks that is not in the 5,500 pages. Correct. So then why do you need the disks? They're just duplicative. Well, we gave them, so the disks do have the transcripts and the classified interviews. The disks also include the audio for the interviews. Oh, okay, audio. We provided, I think technically under Rule 16, since the photographs were taken during the warrant, that's something that's in the rules. So you still need to go through all the disks and all the paper and do the cross-reference to ensure everything have actually been reviewed. So even if there is duplication, it still takes time to determine it's a duplicate, right? You say this like a backup copy. Some people like a hard copy of the book, and you also get the Kindle version, right? Because you might want to take it with you digitally. Although these are classified documents, you can't do that. But you still have to match them, okay? Like we trust the publisher, and it's just a book. We don't really, if the page numbers are off, big deal. This is a criminal prosecution. So we're not just taking your duplication at word. Judge says, so good thing you mentioned that, Your Honor, because we have done the cross-referencing for them, which I couldn't care less about. I don't care what they did. They could bake the most beautiful cake in the world. Here it is. I'd take that cake and dump it right in the garbage. Say, thank you, not touching that cake. What's in there? Get out of here with your cakes. I don't want it. We're doing our own cross-referencing. Take your highlighters and your notes and shove it. In our response to their classified discovery letter, we gave them cross-referencing, and they say, okay, and when was cross-referencing done? Monday night? Monday evening? October 30th, maybe? Irving says 30th. Okay. So in terms of the size of the data on the disks, because there was also some back and forth, how much data are we talking about? I don't have the number in front of me, but I don't dispute that, audio files and photographs equal whatever the data is that's on it. It's a lot. Now I went through the judge says, okay, I went through some of the categories with Mr. Blanche about classification reviews. Are those included in there? Yeah, he says, and just to respond on something that Blanche said. It's not just for the 32 documents, the classification reviews. It's for some 340 documents that were there at Mar-a-Lago. So they say, Judge Cannon, so there are no outstanding materials related to classification reviews that need to be turned over. Is that correct? Not from our perspective, Your Honor. You know, they are going to be arguing, we believe, that maybe there is some communications that we should turn over because they're internal. You know, different agencies did reviews and some of their internal materials need to be turned over. We can address that, but we have turned over what we believe is our obligations and what they require us to turn over. All right, Mr. Bratt, now how about their prudential search? Did you look around at all the other agencies around our government to see if they have any exculpatory information that might be useful to Trump? Your Honor, so we did acknowledge that we did some prudential search reviews, but the one thing is, nope, can you show me where that is, where you acknowledge that in your filing? It's on page 10. She pulls it up. Paragraph begins on the bottom of page 10. She pauses for a minute and reads it, pulling it up on the electronic court filing docket. Boom, here it is. Okay, so here, of course, you're making the original point that you are not required to conduct these. You said you don't have to do them. But then there is a statement that there have been, quote, appropriate prudential search requests made and produced. So you said you don't have to do them, but then you said you did some that were appropriate. Is that true? Correct. So first I want to follow up with what you have indicated. I mean, I guess the answer is, quote, yes, we have conducted the reviews that we believe is appropriate. Is that right? Fill in any gaps. So you say you don't have to do them, but you did do some, and the ones that you think that you needed to do or that were appropriate, you did, and you're done. Is that right? Correct. And he says, I would also just state another sort of bedrock principle of criminal procedure is the defense doesn't get discovery on how we did discovery. And we believe we have done and taken the steps necessary to comply with our obligations. And Judge, okay. And we can attest to that. Say, I'm attesting to that now. Well, what about all this other material like the Jenks and the Giglio material for law enforcement witnesses? Has that been produced? He says, we produced everything. Agent notes. We provided all the material. I can address the prosecution team issue, right? So now we're talking about hula hoops and how big the scope is. I've given him everything that we need, but it's only the stuff that is from like the FBI. What about NARA and all these other agencies? So they talk about some SEPA stuff. Here's the judge, Mr. Blanche. On the TV footage, our vendor says 10 years. This is Todd Blanche wrapping it up. We've sent numerous requests to the special counsel to learn how the FBI analyzed the footage, but the FBI will not give us information about how they analyzed the footage. So we're going to follow up with them later today, but the idea that we haven't asked the special counsel for more assistance with the cameras is not true. So Bratt's a liar. Big surprise. Again, I don't want to belabor this hearing, but Bratt says he doesn't have to do certain things. He cited a selective prosecution motion, and there's other materials that we have not been getting from the government. And so, Your Honor, we sent a letter to the special counsel, and in the letter, they said that there are witnesses that undercut their national defense information theory with at least respect to some of the documents. But oh my goodness. And in our letter to the special counsel that we received from the special counsel, they indicated to us that there are witnesses that undercut their NDI national defense information theory, but they won't tell us who the witnesses are. So, Your Honor, just to give you a flavor of what we expect, it's not some expansive demand. It's pretty consistent with the information we've already been here telling you. We do have, Your Honor, we do have class review memos where the intelligence community has concluded that a particular document is classified, and so we have a memo. We have none of the underlying correspondence that led to the conclusion that it was classified. So who made the classification? And we can tell from the correspondence that we do have that exists. So there are conversations about the classification that are taking place by NARA and the people in the Biden administration. That's the type of information that we need, and we should be able to get it. And so they're going to be filing a motion to compel, and the judge, may grant it. The final thing, one comment Bratt made about me being associated with both this case and DC is extraordinarily unfair. We were, and I have been, and President Trump has been completely transparent with all the courts about our schedules. They asked for a jury trial to start the day that Your Honor, he's playing to the judge right now. Judge Cannon, you scheduled a court hearing in this courtroom, and they asked for another trial to start on that day. They're totally disrespecting you. Instead, what Mr. Bratt says is, well, Trump has the right to counsel of his choice, and so he should have hired a different lawyer. Blanche says, I'm going to add one more point, although I don't think this moves the needle, but there's a third trial that's scheduled for New York, and so we're hoping that you're going to give us some leeway on that one. Now, the question here is not the question you started out with. They said, is there another case where one, Judge, you asked this question, and you have not gotten an answer. It was not answered. You asked, is there another case where one, it's not just the DOJ that brings two separate cases against the same defendant in different districts. It's the same office. It's the same special counsel. It's the same office that brought both these cases. It's their choice, and they put the schedule in flux, Your Honor. We were proceeding apace and continued to, and we were here, regrettably, not because of the conduct conduct of Trump, not because of the conduct on anybody on this side of the room, because they say to Your Honor, we'll figure it out closer to May and it's just not appropriate. So Your Honor, thank you. All right, anything further? No. Unless the court has any questions? No. Judge says, well, I'm going to take the 2 motions under advisement, assessed as the best I can, and enter an order as soon as possible to address these multiple moving parts. I want to thank the parties for their assistance. Have a safe trip back. The court is in recess. And so the big question is going to be about the continuance and whether the trial will be taking place in May or whether she's going to bump that out past the next election, which I have an inkling that she might. Because if you postpone it, let's say 3 months, 90 days, May, June, July, August, we're right, so August, September, October, November, I mean, like a 90-day continuance. If you do a 6 months continuance for May, now you're right in November. So maybe at the end of November after the election, because you're too close if you just go 90 days, so you got to go full 6 months. I think that we're probably going to see this one get postponed. And of course, we'll be here to continue to cover it, my friends. Southern District of Florida, Judge Cannon. And what I like most about this is that Jay Bratt got scolded and the judge didn't let him get away with the same type of garbage that we see them getting away with in the DC Circuit Court. And so, my friends, this is the classified documents case. We will be here continuing to cover this. Thank you to Julie Kelly for sharing those transcripts with us. You can follow her at Julie_Kelly2 on the X platform and check her out over at Declassified Live. She does great work on this case, and she was physically there at this hearing. And so be sure to read her update and follow some of her X's as well. We'll continue to cover this trial and all of the other Trump trials. Thank you for subscribing and joining us as we do, and we'll look forward to seeing you on the next one.